Hi, mate.
Alastair, how nice to be interviewed by you. It's my first interview on Scoop.
It is. So I'm here to talk to you about the Ronald Young decision and the appeal in the water case, which looks set to become a case of extreme importance for...
Well, we don't know, do we? but certainly the issues that it's seeking to canvass are very broad. Certainly the applicants have adopted a very broad approach. I don't think there's anything they've left unturned. They've argued everything, the kitchen sink, in terms of treaty and Maori issues.
So the application for the appeal was lodged very quickly, and it's been accepted by the Supreme Court. So
yes.
it's going to be leapfrog.
Well, so it's interesting because it's very hard to get leave to leapfrog the Court of Appeal. It doesn't happen very often. You have to establish that there are exceptional circumstances. So, mind you, it's pretty exceptional, isn't it? And certainly treaty issues of this sort are public interest, and that's how it's defined in the statute the Supreme Court had.
So what I'd like you to start with is perhaps talk a little bit about that context. So what is so extraordinary about this case in terms of, and why is it different from your run-of-the-mill legal actions against the Crown, and even your run-of-the-mill treaty cases for that matter? Well,
because it raises, I think, broader issues, which sets jurisprudence which affects all other cases. So ultimately it's determining a very big issue here, which is about Maori rights and interests in the water. And the difficulty, of course, is that the Crown says it doesn't contest that Maori have those rights and interests, but it's simply saying that it should be allowed to get on with its mixed ownership sell down of shares because it doesn't affect any of that. It can make provision for those rights and interests. But of course what Mai says, well, how can you make provision for them when you don't know what they are? And the difficulty is that many of the applications, or some of the applications that have been made by Maori to determine what those rights are, have not yet been determined.
So I mean, up until this point, until the mixed ownership model, there were a lot of pre-existing water-related cases.
Well, that's true, but not a lot of them had succeeded.
Yeah.
I guess the reason why the share sale down really brings all of this to fruition is because Maori say, well, hang on, now you're on the verge of selling these shares and they may go into foreign hands, and we're concerned that as a consequence of that the Crown really isn't going to be able to properly satisfy our property, well, our water rights and interests once that happens. And I mean, there's a range of arguments they've made.
And the Crown's argument is basically the reverse, that they will still be able to satisfy any claim that Maori have post this.
Well,
so there's a disagreement in fact
well,
there.
There's a huge disagreement here because in the tribunal I think it was the reverse.
Yes.
I think what happened was the tribunal gave the Crown a really hard time and said, well, it's a no-brainer. There's clearly a link here, whereas Ron Young said, you know, he gave the applicants a difficult time and said, well, it's a no-brainer, there's clearly no link here. Whereas Maori sort of said, look, you are selling these shares, the value of these shares comes from the water, which generates the power. So clearly we're talking here about the value of the water, and so we are not very happy with you coming to a selling these shares down until you properly accommodated our rights. And that's how we got to the Shares Plus, I think, because the Share Plus is not...
Well, the Share Plus was a novel idea that was introduced by the Waitangi
Well, yes, but that's about control.
Yes,
you see, rights and interests, well, what does that mean? We've had this silly argument about ownership and, you know, no one can own water, but really the Share Plus idea is that you get management rights or control of the management of that water, and in that way you satisfy Maori rights.
And Maori seemed reasonably interested in that idea.
Well, I guess so, although, I mean, you know, various iwi and hapu have also made submissions saying that it's not enough.
Yeah.
It's, you know, it's a start, but it's not enough, they want more.
So, I mean, I think it might be worth taking a step back a bit and talk a little bit about the Waitangi Tribunal case and its context in relation to this. So, the Waitangi Tribunal case was held under urgency. It reported back a preliminary report. So there's a final report still yet to come from the tribunal.
And I suppose one of the arguments in the High Court was that without waiting for that second report, as it's known, the Crown really wasn't able, consistent with treaty principles, just to bowl on ahead and sell down. But of course, what the judge found in the High Court was that actually everything that needed to be decided that was relevant to the issues at stake in the High Court had been decided in the first preliminary.
Okay, so let's talk a little bit about the injunction application itself. So the injunction case was held relatively, well, very swiftly.
Well, it was an urgent. It was an urgent case.
application.
So they applied for an interim order. They applied for what we would colloquially call it an injunction. It's essentially an interim order. And what happened was the judge sort of said to Crown Counsel, I mean, do you really need to do it right now? Couldn't you just tie-ho until we actually get this in and argue it? So there was an agreement that the Crown wouldn't do anything further if they pushed for an urgent judicial review, and they got one. So the whole thing's been urgent, and then Ron Young rushed out a judgment as well.
So in terms of the way the injunction application was heard, there was obviously a certain amount of fractiousness between the council and the judge. I think it was reported.
You're now talking about the urgent hearing?
Yeah.
There certainly seems to have been. It's always very difficult.
Yeah.
Counsel appear before judges. Sometimes judges appear to counsel to be very impatient. Sometimes counsel appear to judges to be very dense. And it's difficult. Look, at the end of the day, you go to court and judges pronounce. It's their court. They determine what happens there, and they make the decisions.
Yeah.
So generally what I say to my staff is that they hold the bazooka, it's pointed at you, you have to do what they say, because at the end of the day you're trying to persuade them. So there's no point saying to them, oh look, I'm not interested in what you want to hear about, Judge, I just want to tell you what I think it's all about. That is a total waste of time.
That's
I mean, Alastair, at the end of the day, if the judge sees it differently and he wants a different question answered, then you better start answering his questions, because frankly, they're the only ones that matter in terms of getting the decision you want.
In this case, I sort of almost feel, after reading the judgment, however, that Ronald Young didn't really want to consider the issues. That it was almost as if he sort of wanted to wave it on and say, okay, I'll just give you a blueprint for
the appeal.
For the appeal.
Well, it was obvious that it was going to go all the way. I mean, these sorts of cases do. There's so much at stake. Often you say it won't go all the way because one partner, usually not a non-Crown partner, runs out of money, but the reality is this is so important to Mai that they will push it all the way. You can tell that by the statement of claim. I mean, the statement of claim is an interesting statement of claim.
This
it's not how I would have drafted it,
but
well, no, the one to the High Court as well.
Okay,
I mean, it is. Let's just say it's very broad.
Yeah.
I mean, it's.
But it's everything in the kitchen
well, it's
sink.
designed to say, here's a test case, let's have a go.
Let's
we'd
like
like
raise
to see
every single ground that we can.
What the courts have got to say about these issues, and I haven't had a chance this morning to have a look at the Supreme Court one, but I'm accurately informed, no doubt, by my lawyers that it is equally broad.
That it includes everything.
Which is very frightening for judges. Judges don't like broad; they like narrow.
No, okay.
Narrow.
And I mean that's what struck me about John Young's decision as well. I mean, he has decided. I mean, every page includes a significant, arguable point of law, almost practically, and there's 100 pages, all of which almost amount to mini appeals of their own.
The applicants raised a lot of issues, and there were 3 sets of applicants. So, look, it's a complicated case. And what they sought to argue is everything. I mean, they've argued, we've been arguing. The Crown's also argued some things of its own, but there's prerogative, there's common law, there's customary law, there's statutory law.
And
I mean, you name it.
And there's matters that strikes the very heart of the relationship between the Supreme Court and Parliament as well.
Well, that's true.
In terms of the parliamentary sovereignty in relation to...
If you view it that way, on the other hand, you could argue that just as Parliament is sovereign in passing legislation which has a policy underlying it, which is obviously for sale, the reality is every piece of legislation has a policy which underlies it. But that doesn't mean that Parliament isn't equally sovereign in saying that it can't subject its own powers to conditions, and one of those conditions might be that it's subject to compliance and consistency with the Treaty of Waitangi. The question is, what does that mean? I mean, if if I was the Maori Party, I'd be feeling a little bit sore at this point. They went out there and said to their voters, gee, you're so lucky to have us, because look at what we negotiated. We negotiated a Section 9 SOE equivalent in the MON legislation, but essentially what Justice Young has found is that it's nothing like a Section 9. It's very limited. Essentially, it's limited to consultation. And that's it.
But Justice Young also made some fairly... I mean, he seems to have found squarely in favour of the Crown on just about every single point.
I mean,
it was almost like he did that as,
that's
as a
his
matter
view.
of...
That's his view.
I mean, I wonder if that was actually a structured approach as opposed to actually a view. He wasn't really trying to consider the issues.
That may be because of where you stand on the issues. From his perspective, he wrote a judgment which determined the issues, reflected his views on the issue. I mean, law is a very interesting area because it all has to do with how people interpret legislation, common law, what went on, the facts in this case. And it's very interesting. Sometimes I have clients who ring up and say, well, but I don't want you to give me an opinion that says no, I want you to give me an opinion that says yes. And I say, well, that's the whole point. You want my opinion, and I can say yes, but my opinion is that it's no. And so similarly here, that's what he's decided. And the wonderful thing about our system is that you can appeal.
Yeah.
And we have now got a situation where it's been leapfrogged into the ultimate appeal. I mean, that's it.
Yes,
this is it. The buck stops with the Supreme Court. And what they decide, I mean, for example...
Then binds us all through.
Well, absolutely. So I think one of the critical issues that is going to come up in the Supreme Court is whether Te Hauani Te Hoihoi's good law, whether they're going to overturn it and do something.
This is
a very old case which says that the Treaty of Waitangi is only enforceable to the extent that it's been incorporated into statute. So of course Ron Young says, well, I'm a mere humble High Court judge, I'm bound by that, but of course the Supreme Court isn't, and they could overturn that. And so it will be very interesting to see what they say. We have had some other statements in judgments. We can have an argument about whether they were ratio decidendi obiter, which essentially said that the Treaty of Waitangi is such a core constitutional document that no parliament could ever have intended to legislate contrary to it. I mean, really, at base, if you think about it, this case is specifically related to whether or not there's a nexus between the sell down and the Crown's ability to comply with whatever obligations it's now got under Section 45Q to satisfy Maori rights and interests, whatever they are, because some of them are undetermined. But there is also at base the question of what obligations the Crown has to comply with the treaty in current law.
So I mean, I just one example of that from Ron Young's judgment is that he found that the fact that all of Māoridom gathered at Ngāri Wahia invited the Crown, and the Crown decided that it was going to negotiate with whom it felt it wanted to negotiate.
Was adequate.
Which I'm pretty sure is not viewed as particularly adequate by
well,
Māori.
Māori don't think that. I mean, Māori think it was a fait accompli, and they don't think they consulted with the right people, and I guess we also know, I mean, all I know from the Crown's risk management point of view is that, look, if it takes another couple of weeks to consult with all of the people that they want you to consult with, why wouldn't you do it? Because now we've been held up for months.
So this case...
That's pure pragmatism.
Yes, that is pure pragmatism, which makes you wonder why the Crown is actually proceeding with this case at all. I mean, they could just drop it.
Well...
They could concede it. I'm not sure that the Maori would necessarily drop it at this point.
Well, no, but I mean, from the Crown's point of view, you could say that they can't drop it, because the reality is that even if they sat down now with Māoridom to negotiate, it would take too long, and whatever it is Māoridom wants, they can't give them.
So they'll have to. So it's better to let the courts.
So it's better to let the courts. But you know, ultimately, we might just be going around in a big circle.
Back to Parliament.
Precisely.
Because
if the government doesn't like what the Supreme Court comes up with, well, ultimately there might be pressure for them to legislate. So we may be back all the way to foreshore and seabed, and maybe this is the Maori Party number 2. I don't know. Maybe this is the reinvigoration of the Maori Party.
So just briefly, in terms of the practical matters of this Court of Appeal case, this surely cannot be heard under urgency in the way that the High Court.
Well, it is being heard under urgency. I mean, you know,
but I mean,
I'm hoping to close the office on Friday, and I'm hoping that we have a long hot summer and we reappear on the 14th. Well, on the 18th, the appellants have to file their submissions. Now, the Supreme Court has quite strict rules about what you have to file. And so you have to do it quite carefully and cautiously. They squeeze you for space.
Yes.
Because of course, I can't remember which great author said that, you know, I had to write you a long letter because I didn't have time to write a short letter. So they squeeze them. They make you have to comply with the word requirement, which forces you to come to grips with the issues and to titrate it down. But of course, that's what you should be doing. I mean, for God's sake, you're going to the Supreme Court. You know, that should be refinement, refinement, refinement.
But the Supreme Court itself is not going to want to rush to judgment on this.
Well, I wouldn't have thought so. But the Crown's made it clear that they really need a final decision as of the middle of February if they're going to roll out their mixed ownership model.
But will the Supreme Court care about that?
Well,
I I would have thought that it's not really.
Alistair, you
really
can't
problem,
say
is
that.
it?
You can't say that they don't care. There's a concept called the comity between the branches,
Yeah.
which means that all three branches of government try and accommodate each other. And you can see it. Everyone's been terribly accommodating towards one another. I mean, the Waitangi Tribunal moved faster than I've ever seen them move.
Everybody's
The High
been moving
Court's
enormously
moved
faster.
really, really fast, and I've never seen the Supreme Court move as quickly as this.
Yes.
And for them, I mean, it's
But mid-February to try and consider
well,
this
that's true. It would be
scale
a
of-
record. I think it would be an absolute record for the Supreme Court to bring out a judgment in a fast fashion. But let's see if they can do it. I mean, for the rest of us, I'd have thought that the important thing was to get it right and not get it fast. Because ultimately, if the Supreme Court doesn't get it right, whatever that means, depending on which side of this argument you're on, then I guess we're back before Parliament. And Parliament will legislate it and we'll have a big fight on the floor of the House.
Thank you very much, mate.
You're welcome.